Hi, my name is Natalie, and this is Natalie Lawyer Chick. I'll be discussing popular topics through a legal lens. Make sure that you like, comment, and subscribe.
Hey YouTube, my name is Natalie. Today we're going to be reacting to Sovereign Citizen from courtroom to cuffs. This will be my first time seeing this video. Really excited to react to it. But before we get to that, we are at 10,000 subscribers. Yay! Round of applause. I am so excited. Thank you so much to everyone who is newly subscribed to the channel. Thank you so much to everyone who has been on this channel for a while and has kept returning as the channel has grown and changed a little bit. And I've taken the direction, to these reaction videos and legal analysis. Tomorrow, we're going to be doing a 10,000 live stream in celebration of reaching 10,000. We'll be doing it tomorrow at 2 p.m. Eastern Standard Time. That's Sunday, February 21st. 2021. Looking really forward to seeing you guys there. Make sure that you guys are ready. Can't wait. So excited. And let's get right into this reaction.
Just for the record, I did not want to speak to her because I know I need to gain my rights.
So he just came, this young man is in court and looks like they're filming surreptitiously. And so I will stop to narrate some of what's being said because the surreptitious recordings, the undercover recordings, are more difficult to hear. And I have hearing impaired viewers that cannot always hear what's being said. So already he's off to a bad start because this young man has come up and said that he doesn't want to talk to the prosecutor because he doesn't want to give away any of his rights. First and foremost, you should always have an attorney with you in court. You should never represent yourself. Your attorney would be able to speak to the prosecutor without you facing the possibility of saying anything that could potentially incriminate you. But if you knew exactly how to speak to the prosecutor when you're coming to traffic court or any other type of court, you would at least be able to extract some type of plea bargain from them, know what they are trying to, come at you with, trying to see whether or not they have their witnesses there in court. By failing to interact with the prosecutor before the hearing starts or the trial starts, sometimes you can put yourself at a disadvantage. Sometimes strategically, it's not a good idea to speak to them, but most of the times it is on a limited basis. So if you're talking with them just for the purpose of plea bargaining, usually what you say cannot be used against you. But if you're talking with them for anything outside of that, then what you say can be used against you. So that's why it's very technical and you usually should not represent yourself.
Okay? That's why I talked about that.
You don't have to speak with her. You are not required to speak with her. You have the right to speak to her if you want to. If she wants to visit with you, you have the right to visit with her.
Yes, sir.
So you sort of gave up a right by doing that, but that's all right.
And I also have an affidavit.
And that's what the judge just said. You have the right to speak to her or not to speak with her, but you gave up your right to speak with her by doing that. And again, strategically, there may be circumstances in which you do not want to speak to the prosecutor, but if this is a minor traffic court case, like I think it is, it might have been to his benefit to speak to her. We'll see.
Can I say that to you now?
I don't know what you're talking about.
Affidavit?
An affidavit that you prepared?
Yes, sir.
Not appropriate, right?
So when it comes to, he's trying to present his affidavit to the court. These affidavits do not have the force of law. When you are in criminal court or traffic court, affidavits mean almost nothing. There may be charging documents that are signed by way of affidavit. There may be warrants that are applied for by way of affidavit. But when it comes to a party appearing in court, the only evidence that's taken from those parties is live testimonial evidence. If you want to make a statement, it usually has to be under oath and in the context of being subject to cross-examination. So that's why affidavits don't have any force of law because of the confrontation clause. You have to be able to confront the witnesses and to challenge them on the statements that they make. So you can't just swear an affidavit in front of some third party and then introduce that in court as evidence. It means almost nothing. There's very limited and specific circumstances in which an affidavit is used in criminal or traffic court, and this would not be that particular context.
I just want to know whether you're going to be represented by an attorney.
Oh, and also
That's the first question.
I'm sorry. And also, signing this, saying that I'm waiving my right to have an attorney later on. Like, I just wanted to see how the day was going to go, and if I was going to need an attorney in the trial.
If you hire an attorney, we are not going to turn that attorney away.
All right.
It's just if you're going to apply for appointed counsel, you go now. You should be signing 2 pieces of paper, not just the one. There's one for the driving while suspended and one for the possession of marijuana. Okay, what are you signing under duress?
Because signing this paper is giving up my right, sir, and I don't want to give up my right.
Okay, then hire a lawyer. Fine.
Here's the thing. They have edited this video themselves, but I can actually tell you what's happening because they've edited the video. There's some jump cuts. What's happened is that the judge is going, this is an arraignment or an initial appearance for his charges. And I'm assuming that they're traffic charges. Usually that's why the judge will ask, have you spoken to the prosecutor? Do you guys have an agreement? And if you don't have an agreement, then they'll go through telling you what your charges are. They skip through all of that, right? Because they're cutting off what the judge is saying. In addition, the judge is going to ask you, do you want to hire an attorney or do you want to represent yourself? And because I believe he's a sovereign citizen, usually a part of their dogma is to represent themselves. So in order to ensure that you understand that by representing yourself, you're waiving your right to counsel, right? They will sometimes do an advice and waiver of rights form where the form will explain to you, these are what your rights are. You have the right to remain silent. You have the right to have an attorney. You have the right to this, the right to that, blah, blah, blah. You're presumed to be innocent. Do you understand that? Do you understand by signing this waiver form, you're giving up your right to have an attorney and you're knowingly agreeing to represent yourself so that you can't back out later and say, oh, I went to trial without an attorney or took a plea without an attorney under duress or without fully understanding what my rights were. And so they won't allow you to just sign away that waiver of rights without you vociferously saying, I completely understand what I'm doing, because that's the whole point, is for you to understand what you're doing. And so he's trying to straddle the line here between preserving his right to have an attorney, but rejecting an attorney at this stage because he's probably going to try to get the case dismissed for lack of jurisdiction, right? Which obviously is likely not going to work. So what he's saying is, oh, can I get a lawyer later, but I don't want a lawyer right now. You can get a lawyer whenever you want to get a lawyer, but are you waiving your right to have an attorney right now? And if he's not waiving his right to have an attorney, they can continue the hearing until such time as he comes back to the arraignment with an attorney. So that's why the judge is like, okay, well then you can have an attorney if you don't want to waive your right, because you cannot sign a waiver under duress. If you are under duress, then you're not waiving the right, then the waiver is invalid. So then you want an attorney and the case will be continued for you to have an attorney. The thing that he's trying to do doesn't work because of because of the nature of what a waiver is. You know, it has to be knowing and it has to be voluntary. And if you're saying it's not voluntary and you're being forced to do it, then there is no waiver. And so you are going to get an attorney. And if you come back without an attorney, the judge can take that as like a constructive waiver because you haven't done what needs to be done in order to get an attorney, but he will at least give you the chance to get one.
I'm not going to take it.
Good for him.
Under duress.
He's not going to take the waiver form because he's saying that it's under duress.
And I don't know what word you wrote in there.
Spirit.
Yes, sir.
Opening spirit has been fully, I'll indicate that you're going to retain counsel.
What does that mean?
Hire a lawyer.
So I got to trial over him or come see you over here?
Come back with an attorney.
You're not at trial. And that's the thing, is that you don't even know where you are and what you're doing. This is not his trial date. And the judge is telling him, if you're not going to give up your right to an attorney, which they don't want you to do. I hope a lot of people understand that. The court does not want you to appear without an attorney. They prefer to talk to an attorney. They don't want to talk to pro se litigants who don't know what's happening, who's asking for advice as things are going on. They prefer for you to get an attorney. And so he's not going to accept this half waiver where you're like, oh, I waive, but I reserve my right. No, then you don't waive, you know?
Yes. I was kind of hoping to send it to trial and then get an attorney if I needed.
No. If you sign a waiver of counsel, we can do that. You sign the waiver of counsel. You just sign the waiver of counsel as it is. Don't write anything on it other than your name.
You told me
I chased my mind. You can't just choose some goofy word.
Spirit is not a good word.
Yes, it is.
That's,
Putting the word, I don't understand that at all. Someone's going to have to fill me in on that. But putting the word spirit in the midst of a waiver form is basically invalidating it. You look incompetent, and it has no bearing on the context of what you're doing. Of course, the judge is not going to accept that.
doesn't mean that you're a human being or,
Well,
that is a strange word. Okay?
I mean,
Person or human being, fine. You want to write that in there, but you're not going to write under duress, because if you're doing it under duress, I'm not going to accept it. Okay? I will not accept
well, signing that
anything
paper
that
is
you
giving
sign
me my
that
rights,
says
sir.
you're
I don't want
under
to give up my
duress.
right. I don't want to give up any of my rights. It's my constitutional. It's my constitutional.
So then don't sign the waiver. They don't want you to sign the waiver. It's just that you won't answer the question because he wants to delay. You won't answer the question of, do you want an attorney or not? That's all it is. Like, you don't have to waive your right to an attorney.
Rights and I don't want to keep
It's your constitutional right to have an attorney,
Yes, sir.
or you decide that you don't want to have an attorney.
Yes, sir.
And if you decide you have an attorney, you can apply for appointed counsel. Those are the three things that you have the right to. Okay? If I determine that you are indigent, you have the right to have appointed counsel. Okay?
So under the Sixth Amendment, everyone has the right to an attorney for criminal cases and traffic cases. I'm assuming this is traffic. Also fall under that when the traffic case carries the possibility of jail time. And in our state, you have the right to an attorney for a traffic case when the fine is over $500. So he has the right to an attorney. If he cannot afford one, then he can have what's called appointed counsel, where the court will appoint an attorney to him, and basically the state pays the person or the county pays the person. Or there might be a centralized public defender or legal aid that would represent the person. But basically everyone, no matter their ability to pay, has the right to an attorney when you're facing jail time.
And I've done that. So we just got through going through with some, and she changed her mind, so I'm going to indicate that you're going to retain an attorney then. You don't want to give up any rights. You have the right to an attorney. Or you have the right to waive the attorney by signing this. Or you have the right to apply for appointed counsel. You need to do one of those three things.
I'm really confused. I'm really sorry, sir. I don't know how to do court.
Obviously.
Just answer the question. Just answer the question. You know what I'm saying? It's like he was misinformed. I feel for him. He was misinformed by somebody who got to him before logic could, that, court is one entity and goes one way, and when it doesn't. And this is what the issue is with sovereign citizens. What he just needs to do is just listen to what the judge is saying, and he would have been out of there by now, because this is not his trial date. And if he had just listened, he would have known that, oh, okay, well, I don't want to waive my right to an attorney. I do want an attorney. Or I don't want an attorney. I'll read this form and I'll sign it. But there is no in between. There's no reading the form and then saying, I'm going to sign it, but under duress. It doesn't work that way.
That's why I'm telling you this.
But I guess it's like, I don't know, I thought that it's supposed to go through, and I just wanted to get my trial date and set that, and then come back and continue with the court stuff. And if I needed a lawyer for it, I can go ahead and hire a lawyer later on if I need one.
I'm telling you that I want to know whether you're going to have an attorney. I do not want to get here on the date of your
I
trial.
don't know right now.
Not have an attorney.
I don't know right now. I can say
And refuse to sign a waiver of counsel. We will not do it that way. That is not going to happen that way. Okay?
I don't know how to approach it, sir. I don't know how to go about this.
Okay? Well, I'll tell you what. Come back at 10 o'clock. Think about it. Come back at 10 o'clock.
Honestly, I just figured obtaining an attorney is also giving up rights that I'd rather just represent myself. It's easier to do that.
So he thinks that it is easier for him, who has said his own self, he doesn't understand how court works. And he doesn't know what's going on, even for the simple issue of whether or not he wants to hire an attorney. He doesn't know what's going on, but he's going to represent himself. I don't think that's going to work out. You're not waiving any rights by having an attorney.
Also, signing that waiver of counsel is also giving up rights. I'm here today for real is to verify some things because I'm very misinformed.
it's just these games that they're playing. Like, I'm so confused. I don't understand what's going on. And they think by them asserting that they don't understand what's going on, that it's somehow going to stop the process. You might have a judge who's really nice, who will delay things a little bit to explain it to you, but it doesn't stop the process. The judge can find, you know what, I'm going to appoint you an attorney because I want to make sure all your rights are covered. And I'm going to enter a plea of not guilty for you. And these are what your rights are, and this is what your charges are. See you at the next trial date. Get your life together. You know, they could just do that. So he's not really going to stop the case from happening just because he's pretending like he doesn't understand anything.
Giving up rights, absolutely.
I don't choose to give away any of my rights.
Well, if you're choosing to represent yourself
In the States, yeah.
you are choosing
Represent myself.
giving up rights.
No, you're not giving up any rights to represent.
The judge has said if you're representing yourself, then you are giving up rights. Yes, you're giving up your Sixth Amendment right to counsel. You're just giving that up for no reason.
Representing yourself in the state of Kansas also have. Read these out to you.
That's what I'm going to do.
What's that?
I'm going to appoint an attorney to stand by.
No, sir. I decline. No, sir. I object against that.
Yes. So what you heard what the judges said, here's what we're going to do. I'm going to appoint an attorney to stand by, and the judge has the discretion to do that. You have the right to waive your right to counsel, right? To say, I don't want anyone to represent me. I don't want to give up, I think by having an attorney that gives up rights. And the judge can say, yeah, but I'm still going to appoint standby counsel. They don't do that a lot in my state, but they do that in other states. And what that does is the counsel is there just in case the defendant comes to their senses and changes their mind. They can consult with the attorney to ask them questions. The attorney should be ready to take over if necessary. And this puts the court at ease that the person's rights are still being protected as much as possible while respecting the fact that the person has the right to say, I don't want an attorney. So this is like a half measure that courts are allowed to take to try to still help people who don't want the help.
That I object, and it is legal for you to appoint any attorney.
I'm doing it.
He's practicing law from the bench, and it is frowned upon. That's fraud right there. So you cannot practice.
Practicing law from the bench? How is he practicing law from the bench? He has judicial authority to appoint standby counsel, and he is exercising his authority. He's not advocating one side or the other. In fact, what he's doing is more helpful to you and harmful to the state, if you want to say he's being biased, because he is giving you the benefit of having counsel when the state could just steamroll over you because you clearly don't know what you're doing, right? But he's doing something that's more helpful to the defense than it is to the state, helping them even though they don't want the help. It's very interesting what the court is doing here. And again, not something that my state really does. I don't think they do it at all, but I know other states do it quite frequently.
Attending a lawyer is giving up all my rights to defend myself. On which trial? No, sir. I'm very misinformed about this information. I need some things.
Rights to set this for trial?
No, I need some misinformed about this case, and I have some questions I need to clear it up for.
If you have questions that you need cleared up, then you need to get an attorney because the judge is not there to give you legal advice. Okay, they are not there to explain the law to you. You make your arguments to the court makes legal rulings. They make factual findings if they're the finder of fact, but they're not there to hold your hand and help you represent yourself.
Before we can proceed any further or go anywhere, I need some evidence.
All right, step out of the courtroom, we're going to do the rest of these folks, and then I'll talk to you.
I apologize, no sir.
That's the way it'll happen.
It cannot happen that way. The Constitution says.
Okay, you want to...
Okay, so the court has said, you know what? I'm going to answer your questions, but you're going to step aside so I can help all the other people. And this is what's so messed up is that sovereign citizens do this thing where they basically like take over the courtroom and make it so that other people's cases can't be called, which is really, really unfair. And the judge has told him to step aside, which is an order of the court. And he has said no. So he is in defiance of an order of the court. Let's see how far that takes him.
Take him to jail then?
No, you can't touch me.
Take him to
Like
jail.
this, you can go contempt of court if the judge
You
orders
You
you.
cannot contempt the court. Jurisdiction has been. I apologize, but I'm challenging your jurisdiction, sir. Once jurisdiction has been established, jurisdiction must be proven. I apologize.
Your choice right now. Step out of the courtroom.
If any of you officers put your hands on me, that would be assault. You have no.
Go to jail for contempt of court. Okay?
You have. The court's already in contempt, sir.
The court's
Already in contempt.
The court's in contempt? Quick little legal minute right here. The court is not in contempt. The court has given him fair warning. They have not taken him out of the courtroom. The court has told him that if you do not conform your behavior to my orders, I will hold you in contempt. That is what's necessary for direct contempt. They don't need to have a contempt hearing, like constructive contempt. They don't need to have a show cause. All they need to do is show that the court has given a legal and valid order. And since the judge is allowed to be in control of the conduct of the proceedings, he can tell people to leave the courtroom or to step aside or, things like that in order to manage the flow of the courtroom. He is not following this judge's lawful order. And the judge has warned him that if you don't follow the order, I'm going to hold you in contempt. So he is primed to go to jail right now for contempt of court, for direct criminal contempt. And they do have jurisdiction over this particular issue of contempt. Even if he has a jurisdiction argument over the underlying case, they definitely have jurisdiction over the contempt because it's happening in the courtroom right in front of the judge.
The court.
What? All I need to do.
You're
You're gonna need to turn around, put your hands behind your back.
Oh, he found
You have
me.
no right to
I
say
do. The
anything.
judge just ordered contempt of court. You need to
The
put your
court
hands
has no
behind your
judge.
back.
You operate under your own authority. Anything you do.
You understand?
No, I do not understand. No, I do not understand. Never understand.
Understand
Anything
this,
you
you're
do,
under
anything you do is under your own authority, sir.
Okay.
You put hands on me, that'll be assault.
No,
This,
not
Your
assault.
Honor, here.
What you're gonna need to do is you're gonna need to put your hands behind your back. Okay?
Your Honor, I have some questions that I need.
You're under arrest. Your name's Muhammad, right?
The court is in session. I'm God. I am God.
Yes.
I am God.
So,
I'm God appearing in front of this courtroom right today.
Muhammad,
I am
you
God.
put your hands behind your back.
All right, Your Honor. I have a few questions that I need answers first.
He has no self-awareness whatsoever. He is so bold and so disrespectful. He has no self-awareness whatsoever. He's sitting here talking about you have questions. Question time is over, baby. Question and answer time is over. It is jail time. Oh my gosh.
I am not answering questions for you at this point.
Is this a criminal offense or a civil offense?
It is a criminal offense.
It's a
yes.
criminal offense. Let me type this down.
Hey, Muhammad,
Under what jurisdiction is this criminal
I
offense?
am not going to answer any more questions for you. I told you under what circumstances.
The Constitution gives you two common. You have two jurisdictions under the
The rest of
Constitution.
these people, you're interfering with.
This is
them.
my court case right now. This is my courtroom. I control this courtroom.
yeah.
I control the courtroom right
Hang on
now.
a second.
I apologize.
Been signal 18.
If this is a criminal,
Go ahead and put your hands behind
you
your back.
have two jurisdictions under a criminal investigation.
Muhammad,
It is
right now we're placing you under arrest. So
Under-
do
under
not
what?
resist,
Under
okay?
what? Under
Do
what?
not resist.
What's your
Put
probable
hands
cause?
behind
What's
your
your
back.
probable cause?
Okay.
What's probable cause?
Because
You need
judge
probable
ordered
cause.
you-
The probable cause is the direct order of the court.
This is assault. This is assault. Assault.
Oh my gosh, what an absolute idiot that guy is. I mean, he's still going as he's being arrested. You're assaulting me. Actually, the state is authorized to use physical force in order to take you under arrest, right? They're acting within their lawful authority. The judge ordered you to be taken to jail, and now you're being taken to jail. I mean, it's so dumb because it did not have to happen, right? That was completely unnecessary. He could have just said, I waive my right to an attorney. I want to represent myself. I'm going to sign this form because I want to represent myself. And then come back the next day or the next court date and raise your issues of jurisdiction. Raise whatever issues that you want to have. Have your trial. Plead not guilty, and then just represent yourself. Or you could have had an attorney. Either way, him going to jail was completely of his own doing and such a stupid waste of everyone's time that day. I hate it. He gets no stars. F. He did terrible. Oh my gosh. Don't forget to like, comment, and subscribe. Make sure that you check out my other videos and tune in tomorrow, 2 p.m. Eastern Standard Time, February 21st, 2021, where we will be doing a 10,000 live stream. I'll talk to you later.